that one case, and that happened fairly early in my career, really did help me redefine, hey, what does winning really mean in this process?
Helping families and businesses transform conflict is a full-time calling for mediator Kevin Fuller. Kevin is a well-respected and very experienced trial attorney who has tried cases across Texas in front of judges and juries. And Kevin will tell you that when he was his most successful in litigation, he often saw how devastating the results could be. Kevin's here today to talk with us about mediation, about alternative dispute resolution, and collaborative divorce. Kevin, thank you so much for taking time out of your busy day to be here with us.
It's great to be with you.
Tell us how your experience as a trial attorney has shaped your commitment to helping families find resolution.
Well, I think all those years I spent in the courtroom helped me fully appreciate what that system could and couldn't do for people, for families, for children, for businesses, and I don't think I would have the passion for mediation, the passion for collaborative law, the passion for alternative dispute resolution processes that I have without spending all those years in the courtroom and seeing how that really worked and how it really didn't work.
I love it. I took that right off of your website when you say that when you were at your most successful, it was most destructive for families. What do you mean by that?
Well, the courtroom is kind of the end result of our adversary process, and you hear trial lawyers and people talk about it as a battle, as a war. It's certainly all that. It's destructive in the sense, just from a material standpoint, to go into court, to be successful in court, to get the best results that you can, that costs a lot of money. And many times I found myself in court and, maybe we won $100,000, or maybe we won $500,000, or maybe we won $1 million. But it costs, if it was a $100,000 case, it costs $75,000 in attorney's fees to go win that battle. And to me, that might have been a win for me personally as a trial lawyer, but it was hard to look at that and call that a win. And I tell people all the time, I got tired of winning nuclear wars, of going to court, getting the court or the jury to do pretty much what I was asking them to do. But for my clients, it being a huge disaster of one kind or another. So the material part was part of it. To me, the even worse part, though, is a lot of times the things that parents have to do and say in court to advocate their case or try to show what they're showing. The things that lawyers do and say in court to try to win are really, really destructive to families, to relationships. There are things that are said and done in courtrooms that cannot be unsaid or undone. And a lot of those are really painful. A lot of those are really destructive. And, achieving a win at the cost of destroying what little relationship you had with your former spouse, with the mother or father of your children, a lot of times that's a really hollow victory over the long term, especially for the children. Businesses get destroyed a lot of times in litigation. I used to tell my business clients, I said, look, we go to court all your competitors, maybe your creditors, maybe Uncle Sam, the tax folks, they're going to be watching. And I had a number of clients, come through the divorce successfully, only to turn around and get in a battle with their partners or competitors, learn something about the business, from the fallout of the divorce and use that to their advantage. Banks got scared, called loans that they normally wouldn't have called. People lost careers and jobs over what they had to talk about in their divorce that didn't sit well with their companies, especially people who had jobs in publicly traded companies or in government or something like that. And so, winning a divorce case at the expense of all those things, again, it's, oh boy, we won a nuclear war. And so what kind of win is that?
Exactly. And I think people, if they've been fortunate enough not to have to go through the litigation process, aren't always aware that, when the case is over at the trial court, it doesn't mean the war is over, right? And so they can end up facing years of litigation after they get the win. And it doesn't end there.
Many of the bigger trials that I tried in my career, I had sitting in the courtroom behind me a team of appellate lawyers that were watching the trial, always telling me all the stuff I was doing wrong, all that kind of stuff. But their job was, especially some of the harder cases, the messier cases where we anticipated a courtroom loss, that team was there to look for errors, look for ways to appeal, look for things to do on the next level. And a lot of my litigation clients, I would tell, the ones, not the ones that were kind of defending all the noise, maybe the rich tycoon, not that person, but maybe the person who was attacking the power or trying to get money from the person that controlled it. I would tell them many times, if we're going to go through this process and really be successful, you need to mentally, financially, emotionally, spiritually prepare yourself for what might be a 5 to 10 year war to get through all ends of the litigation process. And there's not many people that are set up in a way where they can wait that long for their financial result anyway out of a divorce. And it's just part of our process. The trial, the winning at trial, that's round 1. Court of Appeals is round 2. Supreme Court of Texas is round 3. Up to the Supreme Court of the United States, if that's there, is round 4. Some people take bankruptcy along the way, and that creates a round 5. And I mean, that's a lot of litigation.
And just trying to get the award creates a whole nother round as well.
My dad used to say there's the check you can get the jury to write, and then there's the check you can cash, and you need to pay attention to the check you can cash.
Exactly. And another thing a lot of people aren't aware of is they think family law proceedings are private in the courthouse, and they're not. They are open in most cases for people from the public to come in, and these days they're on YouTube. So that's something people need to be considering is how public do you want all of your affairs.
That's right. And that to me, that is a major consideration for a lot of families that have competitive businesses. Are you sure you want to have a lawsuit, litigate that in a forum that's public, and really people that don't like you so much, maybe your business competitors or enemies, have access to whatever's going on in your divorce, and that's rarely does a family want to show so much of themselves to other people.
So years ago, while you were still in private practice, representing clients in the divorce process, you became a leader in the collaborative divorce process. Tell us a little bit about your journey into learning about collaborative divorce and really taking it on.
I think it really kind of follows my maturity as a human being in a little bit. When I first started as a lawyer, I wanted to be a trial lawyer. I didn't really care what kind of lawsuits I was trying. I wanted to be in the courtroom. And right at first, man, I loved being in the courtroom. I loved, to me, it was like playing football with a suit on. I mean, I just loved the competitiveness of it all, the strategy, the theater. I love that part of being a trial lawyer. But pretty early on, after I'd been at it 4 or 5 years, just kind of the impact that all that was having on real life human beings and children and families and people really, kind of started taking its toll on me. I was having to pause and look what all my competitiveness was costing people, and not just in money. And I think that started grinding on me. And along the way, I ran into this problem of what does winning mean. I'll never forget, I had a case early on, husband and wife. The husband had a girlfriend, big job, lots of money, real powerful. My client had next to no job, kind of no power in the relationship. And we were negotiating, and I remember, the guy made a 50-50 to the penny offer on not a huge estate at all, probably less than $200,000, but a 50-50 offer. And I was offended by that. My client was certainly offended by that. I mean, this guy had an affair, had lots of money, and I remember kind of telling him, that ain't ever going to happen. I'll see your butt in court. That was back when I was young and cocky and all that kind of stuff. So off to court we go, and this guy's on the stand. I'm just, chewing on him the whole time. He's just looking at me, with this look. His girlfriend comes to court. I chew on her. I mean, we have a trial. After it's over with, my client is, so grateful, that her husband was held to account, that this other woman was brought to the courthouse and shamed, I guess, if you will. But the guy, when we were leaving the deal, he said, I want you to go back and look at my letter of June 1st, 95, whatever it was. I want you to go look at that offer. And that's all he said. I went, all right, yeah, sure, right, buddy. I was just... And so the case was over. We got the ruling, got a nice split, 60-65 split. I mean, it was, as trial lawyers would talk about it, it was a whooping. But I eventually did go look at that letter. And his 50-50 offer that he had made me like a year and a half before we tried the case, when I looked at the dollar amounts that were there for my client, mm-hmm. and what I got her from whooping him in the courtroom, it was significantly less. And in terms of what my client really needed to take care of herself, to take care of her kids, with almost no job prospects, no real way to accumulate wealth, that difference, that $50,000 to $75,000 difference, whatever it was, had a huge impact on it. And, that changed me, because it kind of redefined what a win is in family law. And, that one case, and that happened fairly early in my career, really did help me redefine, hey, what does winning really mean in this process, and made me pay more attention to that. And so that pushed me more and more to look at, maybe it was okay to settle a case. I didn't have to fight everything that moved. And then once I started trying to learn how to settle cases, one of the problems I had in the adversary process, and this is back when mediation was first starting, nobody wanted to play. Everybody wanted to play courtroom. Nobody wanted to play settlement. And so it was really hard sometimes to get people to seriously discuss settlement.
Why do you think that is? What was it at the time? Because I think we still run into that today, where people really feel like, fighting it out is the way to go. But I always say it's like an itch. If you scratch it, you end up with a big wound.
Yeah, I think some of it was just the culture of family lawyers at the time. We very much looked upon ourselves as trial lawyers, as warriors and protectors of the people that we represented, and it was a little bit of a culture thing. I've been doing this a little over 35 years now, and it's changed a bunch, and changed for the better. I think a family lawyer today, a really good one, certainly has the ability to go in our legal system and be an advocate in that environment, but as a profession, we're taking a more holistic approach to, hey, what are we doing here? What does a win look like for a family? And so it's a little less, let's sort this out in court, and a little more, court is becoming more and more a place of last resort instead of first instinct. Mm-hmm. And so, when collaborative came along in, I guess, 2001 or 2, I was instantly drawn to it because it changed the playing field. The whole legal process is an adversary process. I mean, it's the whole design of all our rules of procedure, rules of evidence, all that kind of stuff is to set up the rules for what the battle is going to look like. And so all the end games lead to that courtroom. Now,
I want to interject here real quick, because we throw around adversarial process all the time because we know what that means. But a lot of people who might be watching this don't really know. They may have some idea. How do you define an adversarial process?
So it's just a contested environment, and I mean it's a you say the house is worth $100,000. I say, well, not so much. Okay, that's pretty common in all environments. But we go have a contest about it, and you put your witness on the stand, your appraiser, and I'm trying to attack that appraiser as either being an idiot or lying or doesn't know what they're doing or appraised the wrong house or whatever it is. And that's without regard to what the true value of the house is. I don't care. I care what my client says it is, and that's what that process is about. Same thing for my opponent. They don't really care what the true value of the house is. They only care what their client says it is. And so it's a pitched battle, and
right.
Then the judge decides.
And I think what you just used was a really key term that people don't understand, that you're taking mothers and fathers, husbands and wives, and you're making them opponents. They are playing against each other.
Oh, it's with kids. I tell my mediation clients this all the time. Our mental health community tells us maybe the worst thing we can do with our children is have parental conflict in the home. Whether you're a married couple or a divorcing couple, conflict in the presence of your kids, their awareness, one of the most damaging things we can do as parents to our children. And so the family law system says, oh, the problem is parental conflict. Oh, we got a great answer for that. You're not arguing hard enough. You need a professional arguer to help you make your points. And so what we'll do is this poor family that's in conflict, we're going to go get a couple of professional arguers and put you in a pitched battle, and we'll figure out who's right on this thing. Oh my God. What kind of answer is that? What kind of answer is that for conflict?
And I think, when you've been doing this a while, what you see happen is how serious of an impact it has on children. And you don't have to be a mental health professional to know when you've got your clients' kiddos who are ending up in a psych ward because of the parental conflict, or they're threatening suicide,
or worse.
The costs are so high for parental conflict.
People people all the time, because I'm a divorce lawyer, say, well, tell us some war stories. And back in the day, I had a list of 4 or 5 stories that I would tell that I thought were funny. And looking back on them, my war stories now are how many clients I've had or their spouses who have taken their own lives, either during the divorcing process or shortly thereafter. How many children we've lost to suicide because of kind of the fallout from all that professional arguing at its worst. Not every case is like that by any means, but a lot, too many of them have ended that way. And I can look at a lot of the jury trials that I've tried, and with a significant number of them, there is fallout like that, and it's devastating. And so you were, what motivated me? Well, I really didn't like being a part of that. I was having trouble getting people to play settlement, and the whole process I was involved in was a fighting process versus a solution process. And so when collaborative came along, from the biggest viewpoint, it's a process that says, look, we've got problems, we've got conflict, nobody agrees, nobody likes each other, we got all that. But we're going to set up a process where the end game is not a battle, it's not a war, it's a solution. That's what we're trying to come to, is a solution without a war or a battle. And so it's a completely different game. In the collaborative process, the lawyers act different because they're not trying to set the other lawyer or their client up to be taken down, in some kind of litigation context. There's certainly advocacy going on, but it's at a completely different level with a completely different purpose. And so I love that. Finally I could get somebody to play settlement with me that was really going to play settlement. They weren't gaming me to just cut my legs out from under me in a trial somewhere.
Because one of the important features of collaborative is the collaborative commitment that the professionals also make. So if the case doesn't settle in collaborative divorce, right, the lawyers get fired. Right. So that means we all have a vested interest when we're sitting around that table.
And that's a big deal. The biggest mistakes I made as a lawyer representing clients was either, they came in 2 flavors. Either I had my war general hat on when I should have had my diplomat hat on, or it's just the opposite. I had my diplomat hat on when I should have had my war general hat on. And the thing I like about the collaborative option is it sets up a process where it's safer for me as an attorney trying to help somebody to know, hey, in this process, the only hat I wear is the diplomat's hat. I'm not going to make a strategic general's mistake in this environment because it's all solution. It's all peacemaking, maybe too strong of a word, but it is a solution-making process. In the litigation process, it's still hard. There's a lot of settlement that goes on in the litigation process. Far and away, most cases settle in that process. But for the lawyer, you got to wear 2 hats. You got to keep your war general hat on because you are in a process where the other side has a constitutional right to take you to a jury trial if they want to. At the same time,
I'm going to interject there because I think that's another thing that people don't often realize is that in Texas, our family law cases, our divorce cases and custody cases can be tried in front of a jury.
And And people have a constitutional, undeniable right to do that. And that's bad. I mean, that is a big battle, a big contest. And so when you're a lawyer in a normal litigation case, you need to keep your eyes and ears open, because there is always a possibility that the case can come completely off the rails, and you've got to be thinking about what you did and said in a courtroom context. At the same time, as we've been talking about, for most families, most couples, most businesses, ending things with a contested trial is not the way to go. And so you're trying to be diplomatic, but you still got to keep your eye. It's hard. It makes the lawyer's job incredibly hard to skillfully maneuver their client through kind of both of those paths. In collaborative, the focus is singular. I don't have to worry about all that. I'm absolutely still an advocate and trying to help my client and get their interests met and all those sorts of things. But I don't have to worry about all the strategic games, if you will, that I do when I'm in the other system.
I love the focus on solutions. How have you seen collaborative divorce benefit the people that, either clients or even in your work as a mediator? How have you seen it benefit people, families?
Lots of ways. First, let's just talk about money, material. I'm more active as a mediator now than anything else. That's pretty much exclusively what I'm doing these days. But when I was an active collaborative lawyer, I was also an active trial lawyer at the same time. And one of the statistics that I kept at the time was how much is all this costing my clients. And when I kind of finished up my collaborative active career, I had close to 100 cases. And I could take the fees that my clients had paid me from those 100 collaborative cases, and with what the fees that my clients paid me from 6 of my litigation cases would have paid for all 100 of the collaborative cases. And most of my collaborative cases were substantial cases, big complicated cases with a lot of issues and controversies in them. So, 100 for the price of, 6 for the price. I mean, that was a huge thing. The second thing is for my financial clients, where we were involved in businesses, trying to distribute wealth out of a business or something like that. My results for those clients, no comparison to what was available to them in our litigation process or going to court. None. So they got better financial results, both ends, whoever was paying, whoever was receiving.
And part of that is, I also think people don't realize, is that courts are constrained by the family code in terms of what options they have available to them.
Right.
And so when we're working outside of the courts, anything's possible. We don't have those same restrictions in place. So
the court's got maybe 3 or 4 tools.
Yeah.
In the collaborative process or other, you may have 1,000 tools to fix that same problems. Families, children. Oh my goodness. Any divorce is hard. Going to be, I think, the most devastating, difficult thing that anybody ever goes through. But, the collaborative process helps with that, but it doesn't take away how hard it is, how difficult and painful it is. But the process is not anywhere near as destructive. And so the difference in sort of what those children's lives look like, kind of post-divorce is not really comparable.
It's night and day.
Night and day. And so that's a benefit. And then, time, goodness grief, wear and tear on your spirit, your soul, your kind of mental health, emotional health. kind of no comparison. Not to say that the collaborative process and mediation and those kinds of things are easy, but they're way, 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 way less worse than the contested environment of a courtroom.
I think that's such an important point to drive home, in part because when we're settling either in mediation or in collaborative, it is focused on solution. Where in litigation, it's focused on, arguments and destruction and winning and losing. It's making the other side lose is what the focus is.
It's winning your point,
yeah.
whatever it is.
And it comes at a high cost. So I want to switch a little bit and talk about your mediation practice. You and your wife, Charla, who's also a very experienced trial attorney and mediator, left the practice of law several years ago and to commit yourselves to helping families mediate controversies. So tell us a little bit about that transition and how things are working for you all right now.
It's just been great on every level. In my professional life, and I think Charlotte would say the same thing. Well, I'll just speak for me. In my professional life, when I was at my old firm, like I said, I was doing collaborative cases and I was doing litigation cases. And so I was always doing both, and had a lot of internal conflict about that. Had a lot of difficulty being able to focus on truly what my passion was, which was, when I got towards the end of my courtroom career, it was really more about solutions than courthouse victories. And so by becoming a full-time mediator, I got to stay 100% in the solution business. And for me personally, professionally, man, I really, really, really love that. Every day, my job is to try to come into a family and help them find a solution that's constructive, hopefully. But if we can't get to constructive, it's less worse than what their other alternatives are. And I love having that as my kind of only job. I don't have this other job, that calls me into battle. And that's one of the things I like about it. As a human, as just a person, it's been way, way easier, just on me personally, on my spirit, on my soul, on my mental health and emotional health. I mean, I've just got a great job. I'm not trying to hurt anybody. I'm not trying to embarrass anybody or shame anybody or destroy anybody or having to protect people from those things. It's just a different environment, and I've really, really, really been enjoying it.
We often hear that, most cases will end up settling before they go to court, which in most instances is a very good thing. Can you shed a little more light on that? Like, what are the odds a case is going to settle in mediation? Why should somebody be considering mediation?
I think I keep statistics on everything, and in terms of cases that have settled. Out of my practice, it's around 94%. I think that's about the same as sort of litigation cases in general. 90 to 95% of cases are most likely going to settle without having to go to a full contested trial. The thing is, where along the way do you want to settle? To me, the settlements that come at the courthouse steps when you're on the very eve of trial, a lot of times those settlements are coming about because somebody missed a procedural deadline of some kind that has nothing to do with the merits of the case. It just has to do with the procedure of the trial. There a lot more coercion, a lot more pressure, all that kind of stuff. The other thing is, if you settle on the eve of court, chances are great you're out of money. And so settling short of that and settling in a different context, to me, is a huge benefit. some of these cases that go to trial, they've been in our legal system for a year, year and a half, 2 years. I've tried cases that are 5 years old that are getting their first trial. And if they've been in court fighting each other those whole 5 years, you burn up a lot of money, but you also burn up a lot of relationship, goodwill. Things get done and said in depositions and discovery and temporary hearings that are hurtful and hard to take back. In collaborative or mediation, you want to be well informed. You want to have enough information to make an informed decision about what you're doing. But as soon as you get to that spot, I think it's good to go into one of those environments and try to settle if you can, and save the time and the money and the angst and the anxiety of hanging around in a litigation posture for 2 years or something.
If somebody is scheduled to go to mediation, what tips do you have? What can people do to prepare themselves for mediation?
Well, there's a lot. In my practice, when we set a mediation, Charlotte and I send out a little mediation preparation form. And I think being prepared for mediation is just the most effective thing that you can do to be successful in mediation. And so what is preparation? One, on the finances, it's being sure you've listed all your assets, you've gathered, these are the assets that we have. Here's the most current information that we have on what they're worth, or how much money's in the bank account or the retirement account or the balance on the credit card, whatever it is. Organizing that information, thinking about, is it separate or is it community? What are the arguments? How difficult is it to prove? All those sorts of things. But really getting organized before you come to mediation. The second biggest thing is to do a lot of thinking about, gee, what is it that I want? And why do I want it? When I ask people that question, they'll say, well, I want what's fair. And fair is okay. I mean, that's a human internal compass that we all use to try to figure out, what's right and what's wrong. The challenge is, if you got 4 people sitting at a table, all their internal compasses on what is fair is going to be a little different, because their perspective is a little different. And so I think you need to think more about that. What I want is, I want to be able to keep the house, or what I want is the most cash flow I can figure out how to get so I can pay for the kids' private school, or what I need is the most liquidity because I've got this coming up or that coming up. And think about your strategic goals and have a good sense of, hey, what is in my own selfish best interest? What's fair for me, but what does that really look like in terms of a result? Then the last thing is doing some thinking about what your options are. I talk all the time about BATNA and WATNA. And BATNA is if your best alternative to a negotiated agreement. And so it's like, if we don't settle, what's my best possible outcome in the litigation system? What does that look like? If we don't settle, what's my worst possible outcome in the litigation system? And to be as honest about those two things as you can figure out how to be. And this is really the lawyer's job. But if you come to mediation or negotiation environment and you've got enough information to make an informed decision about what you're doing, you know what you want, and you can look at the offers and options that are coming down the pike and say, well, that meets my interest. Oh, that one's way off. We need to change it. It gives you a great compass. Hey, am I making progress? Is this a deal I ought to look at taking? And then strategically, comparing it to your other options, it gives you a sense of, hey, this is way better than I could do on my best day, or at least this is better than I could do on my worst day. Those kinds of things.
That's great. And I'm sitting here thinking of the many mediations that I've attended where you've been the mediator, and the relief that comes for many clients in the days that follow. It's not unusual sometimes to have a little buyer's remorse, maybe, because it's a big deal when the mediation is done and you've settled.
It's hard.
It's over. I mean, that is it's a done deal. And so people need to be careful when they do that. But often, more times than not, what I see my clients experience is the relief.
Right. You have some certainty about what your future is going to look like. And, that's one of the biggest things about going to court is lawyers can say, well, the system does this, can do this, can't do, we've got laws that the courts are supposed to follow. But there's a huge degree of unpredictability about results in our legal system. And at least when you settle, well, here's what I've got to work with. Here's what I've got to go forward with. And then you can start working on that versus just being worried to death about, how's it going to come out in court.
Exactly. And really helping people start that next chapter. I mean, that's what mediation allows them. Kevin, I want to thank you for the work that you do and for taking time to come and spend with us today. We're going to include links to fullermediations.com so people can learn more about your mediation practice and Charlotte's as well.
Sure.
And reach out to you all. Do you do non-attorney mediations? Do you help families?
We do some. Mm-hmm. That's not a piece of our practice that we are able to. It's more than anything else. It's a scheduling problem. How to fit folks in on a parties that are coming in without lawyers, and how to do that. But yeah, we do that, and I think it's an option that more people ought to look at. We could talk for a long time on the pros and cons of doing that, but for many couples, I guess between Charlotte and I, we've maybe done 50 to 75 mediations where the parties come in without attorneys. For some cases, that can be a really appropriate way to go about it from a cost perspective, but it's by no means right for most cases.
Right. Well, thank you again, and we'll look forward to following up with you.
All right. Well, thank you for having me.